Article 1202. The debtor shall lose the right of choice one among the prestations whereby he is alternatively bound. Only one is practicable. Notes. Right of choice of the debtor, presumed by law. The right of choice implies that the debtor can freely destroy the other choices, as long as one still remains. To have effect, it must be communicated to the creditor. Mode of communication may vary. This right of choice implies that the prestations are not impossible, unlawful, or those which could not have been the object of the obligation. The debtor cannot choose such prestations. In addition, the right of choice is lost when only one prestation is practicable. Practicable means capable of being done, or feasible. Creditor cannot complain. Article 1203. If through the creditor's acts the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. Article 1204. The creditor shall have a right to indemnity for damages 1. Through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. Notes. Loss of alternatives. Creditor's fault. If nothing in the prestations is possible because of the fault of the creditor, the debtor can rescind the contract plus damages, or provided that there are still viable alternatives left. The debtor can still choose among the other alternatives if the creditor still wants to pursue the contract debtor's fault, damages based on the last thing lost or the service which became impossible, plus other damages. Article 1205. When the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. 1. If one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. 2. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which, through the fault of the former, has disappeared, with a right to damages. 3. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with indemnity for damages. The same rules shall be applied to obligations to do or not to do in case 1. Some or all of the prestations should become impossible. When the choice is expressly given to the creditor, obligation shall cease to be alternative. However, the following rules will govern the obligation while the selection of the creditor has not been communicated. 1. If the debtor loses one of the choices through fortuitous event, the debtor can perform the obligation by delivering that which the creditor chooses, or delivering the remaining choice, if one is left. 2. If the debtor loses one of the choices through his or her own fault, the creditor may claim any of the subsisting alternatives, or the price of that alternative which disappeared because of the debtor, plus damages. 3. If the debtor loses all of the choices through his or her own fault, the creditor can claim the price of any of the things lost, plus damages. Article 1206. When only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. The loss or deterioration of the thing intended as a substitute, through the negligence of the obligor, does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. Notes. Facultative alternative obligation involves a principal obligation and a substitute obligation. General rule, that the substitute must be given in case the principal obligation is not fulfilled is not mandatory. Exception, however, there is nothing stopping the parties from stipulating such in the contract. Moreover, if the debtor does give the substitute in place of the principal, the creditor cannot decline. A facultative alternative obligation is voidable when the substitute is a consideration crucial to the agreement of one of the parties to the obligation, and there was fraud involved with the substitute object. Becomes valid if the creditor, however, accepts the principal object. The contract is cured of the fraud involving the substitute. Section 4. Joint and Solidary Obligations. Article 1207. The concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand, or that each one of the latter is bound to render entire compliance with the prestation. There is a solidary liability only when the obligation expressly so states, or when the law or the nature of the obligation requires solidarity. Notes: solidary obligations. Nature implies a situation where there are debts or obligations incurred by two or more debtors in favor of two or more creditors, and giving anyone, some or all of the creditors the right to demand from anyone, some or all of the debtors the satisfaction of the total obligation and not merely the share of each debtor in the debts or obligations. Not presumed by law. A solidary obligation exists only when 1. Expressly stated in the contract. However, if a judicial decision supersedes the contract and declares that the obligation is merely joint, then it must be enforced in a joint manner. 2. When the law requires solidarity, e.g., family code, spouses are solidarily liable with their separate properties for liabilities of the APC or CPG if such APC or CPG is insufficient to cover for the unpaid balance. 3. When the nature of the obligation requires solidarity, Article 1922 of the Civil Code, when violated by two or more persons, has been deemed to give rise to a solidary obligation, according to Tolentino. When an obligation is solidary, use of the following terms, individually and jointly liable, collectively, separately, distinctly, respectively, severally, jointly, and severally guaranteed. I promise, or I hereby bind myself, but only if the names were not identified in the body of the contract itself. If a name or some names are identified, obviously it is not a solidary obligation, because a specific person is liable, and not the debtors as a whole. Article 1208. If from the law, or the nature or the wording of the obligations to which the preceding article refers the contrary does not appear, the creditor debt shall be presumed to be divided into as many shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of court governing the multiplicity of suits. Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the others shall not be liable for his share. Notes: joint obligations. Nature presumption of the law is that an obligation is always joint. The joint debtors are obliged to pay only their share in the indebtedness, while the creditors can claim their share in the credit. Joint indivisible obligations. An indivisible obligation is one whose payment cannot be divided. Indivisibility refers to the object of the prestation. Rules. 1. Creditors must act collectively when enforcing the debt. In the same way, the creditors can be prejudiced only by their collective acts. 2. The debtors must also perform the obligation collectively. If one of the debtors fails to perform, indemnity for damages arises. Those who were willing to perform the obligation shall only be liable for their corresponding portion in the price of the thing. Those who refused to perform the obligations shall be liable for their corresponding portion, plus additional damages. 3. In case of insolvency of one of the debtors, the others shall not be responsible for the share of the insolvent debtor. Article 1210. The indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity of itself imply indivisibility. Notes: solidarity refers to the nature of the obligation, while indivisibility of the obligation refers to the nature of the object of prestation. Article 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. Article 1212. Each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. Article 1213. A solidary creditor cannot assign his rights without the consent of the others. Article 1214. The debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Article 1215. Novation, compensation, confusion or omission of the debt, made by any of the solidary creditors or with any of the solidary debtors, shall extinguish the obligation, without prejudice to the provisions of Article 1219. The creditor who may have executed any of these acts, as well as he who collects the debt, shall be liable to the others for the share in the obligation corresponding to them. Article 1216. The creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. Notes: solidary obligations, actions of creditors, collective actions. Creditors can act individually when such acts are beneficial to the others, e.g., one solidary creditor can sue the debtors without the other creditors joining the suit. If such creditor acts prejudicially to the others, he/she may be liable for the other's share in the indebtedness, plus damages. Transfer of rights. No one among the creditors can transfer his/her rights. A transfer of rights may prejudice the other creditors. Receipt of payment. General rule: anyone among the creditors can receive payment. Exception: when a specific solidary creditor makes a judicial or extrajudicial demand, payment should be made to him/her. Sta. Maria thinks the strict interpretation of this provision should be abandoned, considering Article 1212. The proper interpretation should be that the creditor who makes the demand is simply given preference without necessarily curtailing the rights of the other creditors to collect. When an obligation is extinguished, the obligation shall be extinguished whenever any of the solidary creditors with the solidary debtors shall make any of the following actions: a novation, change of the creditors, debtors, or the principal obligation of the contract be compensation, to persons, in their own rights. Are creditors and debtors of each other, see confusion, merger of the characters of debtor and creditor in the same person, remission, condonation of the obligation, to prevent prejudice against the others. The creditor who may have executed any of these acts, as well as he/she who collects the debt, shall be liable to the others for the share in the obligation corresponding to them. Demand of payment. A creditor can proceed against any one or all of the debtors simultaneously. A demand against one is not a bar against a demand against others, as long as the debt is not yet paid. In other words, even though a creditor has a right not to accept partial payment, She can accept partial payment from one of the debtors, as such acceptance does not bar the creditor from collecting from the others. Article 1217. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. He who made the payment may claim from his co-debtors only the share which corresponds to each, with the interest for the payment already made. If the payment is made before the debt is due, no interest for the intervening period may be demanded. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such a share shall be borne by all his co-debtors, in proportion to the debt of each. Article 1218. Payment by a solidary debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or become illegal. Article 1219. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility towards the co-debtors. In case the debt had been totally paid by any one of them before the remission was effected. Article 1220. The remission of the whole obligation, obtained by one of the solidary debtors, does not entitle him to reimbursement from his co-debtors. Article 1221. If the thing has been lost or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. If there was fault on the part of any one of them, all shall be responsible to the creditor, for the price and the payment of damages and interest, without prejudice to their action against the guilty or negligent debtor. If through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. Article 1222. A solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him, or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards the part of the debt for which the latter are responsible. Solidary obligations, actions of obligor's payment, any of the solidary debtors can pay. The creditor may choose from whom among the debtors he will receive payment. The debtor who paid can claim from his co-debtors only their individual shares, plus interest only if the payment was made after the debt is due. If one of the co-debtors is insolvent, such a share shall be borne by the co-debtors, in proportion to the debt of each. A solidary debtor cannot demand from the other co-debtors if he or she made payment after the obligation has prescribed or become illegal. Remission depends on the time the remission was made. Also, as far as Article 1219 is concerned, this is applicable only when there is one creditor. If there are many creditors and one creditor individually made a remission, the remission is an act prejudicial to the others according to Article 1212. If the remission is done, the creditor will be liable for the share the other creditors should receive plus damages, if applicable. A solidary debtor is not entitled to reimbursement when a co-debtor obtained the remission before such solidary debtor has paid the debt on the date due. A solidary debtor is entitled to reimbursement when a co-debtor obtains the remission after such solidary debtor has paid the debt on the date due. Loss of the thing or if prestation becomes impossible, without fault of any of the debtors, obligation is extinguished. With fault of any of the debtors, all shall be liable for damages plus interest, without prejudice to the innocent debtor's actions against the guilty or negligent debtor. Fortuitous event with delay. Apply Choice B Section 5, Divisible and Indivisible Obligations Article 1223. The divisibility or indivisibility of the things that are the object of obligations in which there is only one debtor and only one creditor does not alter or modify the provisions of Chapter 2 of this title. Notes. Simply put, number of creditors or debtors do not affect the nature of the object of the prestation. Article 1224. A joint indivisible obligation gives rise to indemnity for damages from the time any one of the debtors does not comply with his undertaking. The debtors who may have been ready to fulfill their promises shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or of the value of the service in which the obligation consists. Notes. In a joint indivisible obligation, the joint co-debtors must cooperate to fulfill the object of the prestation. In case one of the co-debtors does not cooperate and the obligation is not fulfilled because of his or her non-cooperation, the obligation shall be converted to a claim for damages, but A. The cooperating co-debtors will only be liable for their share in the obligation. B. The non-cooperating co-debtor will be liable for his or her share in the obligation plus the sum of all damages. Article 1225. For the purposes of the preceding articles, obligations to give definite things and those which are not susceptible of partial performance shall be deemed to be indivisible. When the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units, or analogous things which by their nature are susceptible of partial performance, it shall be divisible. However, even though the object or service may be physically divisible, an obligation is indivisible if so provided by law or intended by the parties. In obligations not to do, divisibility or indivisibility shall be determined by the character of the prestation in each particular case. Section 6. Obligations with a penal clause. Article 1226. In obligations with a penal clause, the penalty shall substitute the indemnity for damages and the payment of interests in case of non-compliance, if there is no stipulation to the contrary. Nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code. Notes. Penal provisions. A penal provision is an accessory obligation which the parties attach to a principal obligation for the purpose of ensuring the performance thereof by imposing upon the debtor a special prestation in case the obligation is not fulfilled or is inadequately or irregularly fulfilled. Its purpose is to do away with the necessity of proving damages in case of non-fulfillment. General rule. A penal provision substitutes the indemnity for damages and the interests in case of non-compliance. Exception. If the obligor refuses to pay the penalty or is b. guilty of fraud in the fulfillment of the obligation, damages shall be paid. General rule. The penalty clause is enforced only when it is demandable in accordance with the provisions of this code. Exception. Unless the stipulation of the parties or the nature of the contracts, time is of the essence, otherwise demands. Article 1227. The debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where this right has been expressly reserved for him. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted him. However, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. Article 1228. Proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. Notes. Penalty is an accessory obligation. General rules. A debtor cannot pay the penalty instead of fulfilling the obligation. B. Also, The creditor cannot demand the fulfillment of the obligation and the penalty at the same time. Exceptions. The debtor can pay the penalty if this right has been expressly reserved for him or her. B. Also, the creditor can demand the obligation and the penalty simultaneously if this right has been granted. Special rule. If the creditor requires the obligation to be fulfilled, and performance thereof becomes impossible without his or her fault, the penalty may be imposed. The nullity of the principal obligation also nullifies the penalty clause. However, the nullity of the penalty clause does not extinguish the principal obligation. Article 1229. The judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor, even if there has been no performance. The penalty may also be reduced by the courts if it is iniquitous or unconscionable. Notes: intervention of the courts and penalty clauses. This is one exception to the rule that a contract is the law between the parties. If the penalty is unconscionable, the courts may temper, reduce, or in some cases, delete it. Article 1230. The nullity of the penal clause does not carry with it that of the principal obligation. The nullity of the principal obligation carries with it that of the penal clause.